Welcome to today's video. I'm Richard Chapo. I'm an attorney down in San Diego, California, and I've been advising online businesses for about the last 20 years or so. Although now it's 2019, maybe I can claim 21. But that's another subject. Today we're going to answer the question of, is a privacy policy legally required for your website or your app? And this is an area of law that is surprisingly complex. When I first started practicing internet law in 2000, if somebody had told me that privacy would be the area where we would see conflicts between governments and different jurisdictions and what have you in the future, I probably would have laughed. I would not have thought this is the area where we would see, essentially a world war, if you will, in the online arena. I thought we would be more in the areas of free speech and things of that sort. But it is what it is. So let's take a look at how all this plays out. Let's start with the United States. So if you're in the United States or you're targeting the United States, the important thing to understand is there's no federal privacy law. There just isn't, because of a unique aspect of the U.S. Constitution, which is privacy is never actually mentioned in it. Some would argue it's inferred, and in fact, courts have found a right of privacy based on some of the language in the Constitution. But then you get into these prickly issues like abortion that we don't even want to touch. But those issues, those hot button topics, have really made it very difficult for the U.S. to pass a general privacy law. Because if you do, well, then how do you deal with privacy rights surrounding women's rights and abortion? But that doesn't mean that we don't see federal prosecutions over privacy issues. The Federal Trade Commission, they're known as the FTC, takes a novel approach in this area. As a government agency, the FTC cannot enact laws. They can't create laws. However, they can use what their authorized enforcement authority to go out and effectively do that. And this is one of those situations where we're seeing that. So the FTC is authorized to prevent misleading business practices or deceptive practices in the business market that affect consumers. And so what they will do is, if they get complaints regarding a website and the privacy practices of that website, they will look at the privacy policy. And they are going to launch an enforcement action to see if you are living up to the promises you make in your privacy policy. So if in your privacy policy you're saying you don't rent, information that you gather from visitors to third parties, and in fact it's shown that you do rent those to third-party advertisers who are emailing, those parties, well, you just violated your own privacy policy, and the FTC will seek damages as well as potentially orders forcing you to stop doing that. And so you can get dragged into it, which is certainly very interesting. The other thing we see at the federal law level is there are privacy laws specific to particular subjects, such as collecting information from kids online, or health information, or financial information. So if you're in a specific field of that sort, you certainly want to look into those. Now, you're going to know that already. I mean, if you're thinking about launching a business in that field, at some point you should talk to a CPA or a lawyer, and they're almost assuredly going to mention that because those are major hurdles to deal with. So if we don't have a federal privacy law in the United States, not a general one, you're probably not going to be surprised to learn that states have stepped in to try to fill the gap. And what we have is kind of a hodgepodge mess of privacy laws, because what the states will do is they'll pass their own specific privacy law, and then they'll say, if you sell into our, if you have a nexus with anybody in our state, primarily if you're selling to them, then you need to comply with our privacy laws. And California is kind of the leader in this area because, of course, California would be the leader. And they have different privacy requirements. That you have to mention certain subjects, like, do you track people? What are the other subjects? If you're advertising to minors, are you using information that you collect, to focus on minors? If so, you have to make certain disclosures. If you have more than 20 employees in your company, you have to create a separate privacy policy. You can go to ESPN and look at their privacy policy list. You'll see one specific to California. That's what that is. So there are all kinds of little rules. Now, the problem that this creates is each state passes its own privacy laws, and they often conflict with each other. or they're just different from each other. And so you end up with a website that if you complied with all of them, you have this monster privacy policy nobody's going to be able to read, and it kind of defeats the purpose. If you don't believe this, go to Apple or Facebook and try and read their privacy policies. It's an unmitigated mess. And it's not really their fault. They're trying to comply with all these different areas and different rules and what have you. And it's just not a good idea. So eventually the hope is that we will see a national privacy policy in the United States, a privacy policy, national privacy law, just so that we can simplify things. So this leads us to the privacy wars. You might be very surprised to learn that governments and economic groups and what have you are going nuts on the topic of privacy online. And a lot of it, unfortunately, comes back to the United States and the actions of our government. This isn't a political statement. This is just kind of a statement of fact. It's well known countries spy on each other. Unfortunately, the United States has been both very effective at it and also grossly incompetent. From the NSA to CIA to the FBI, we have some very talented people who are able to breach security platforms for the governments. And so you had situations where the United States, for instance, was copying and reading all the email sent to the German prime minister, things of that sort, which rather sensitive information, and that's fine and all. But the problem was that they didn't do it in a manner that prevented them from being discovered. So as you might be able to understand, some of these authorities in other countries were not too pleased that the United States was essentially copying all their information and reading it. There's an irony when we complain here in the United States about the Chinese hacking the U.S. government when we're doing the exact same thing. So. But of course, that's a story for another video, or probably a story for a book, to be honest. But it is what it is. So anyways, the end result of this is we've seen different areas of the world start issuing new privacy laws and privacy regulations that are much more restrictive than the United States. So the big one, the glamorous, sparkling, flashy thing right now is the General Data Protection Regulation that was passed in the EU a few years back. It went into force in May 2018, May 25th, and it's often referred to as the goddamn privacy regulation. Excuse my French, but the reason for that is that it is one of the more draconian laws I think I've ever seen in my life, and I've read some just horrible laws. To give you an idea of just the stupidity of what we're dealing with in this situation, the GDPR has 99 articles, and so each article explains the requirements for a specific area of privacy law. So like Article 8 deals with collecting information from kids. Article 3 talks about territorial scope, how far does the GDPR reach, and what have you. And then it has 247 recitals. So what are recitals? Recitals are an effort to explain what the drafting party meant in the articles. So you have, essentially 2.5 recitals per article trying to explain what they meant. And if that doesn't sound like a cluster, you know what? Well, it is. And then on top of that, we have guidance issued by the drafting party, which is known as the Article 29 Working Party, a group that deserves all the criticism that they're getting. And then on top of that, we have some court rulings and what have you. And it's just a mess. If you are targeting an audience in the EU, or you are considering selling to those groups, maybe adding them to your mailing list, whatever it is, you need to be aware of the GDPR, and you need to be aware of, their compliance requirements. The compliance requirements are vastly different than the United States. It is just a whole different world. First, you have to have a legal basis for collecting the information, and there are 7 different bases. And then you have to go through a whole compliance process, including mapping how data is collected, shifted, used, stored, and shared with your website. You need to get data protection agreements from each of your vendors who are tracking people through your site. So that would be your plugins, the companies that are using cookies. This is why you're seeing all the cookie pop-ups on websites. And it's a bit of a joke. I'm all in favor of the European Union or other areas trying to institute controls that allow people to control how their information is collected and used. But this is just way over the top. And if you don't think so, and you're one of the people that keeps advocating the GDPR, then let me just point to a specific piece of advice that was given by the Article 29 Working Party. They said, and I swear this is true. They said that if you have a business to business transaction, so let's say I'm in the United States and I want to sell my products to a business in Europe, and say I'm doing that wholesale, and I'm communicating with one person in Europe, Pierre. Okay, well, if I send information to Pierre at an email address that reads purchasing agent at europeancompany.com, then I do not need to comply with the GDPR. However, if I send the same exact email address or the same exact messages to an email address that reads Pierre at europeancompany.com, then I need to comply with the GDPR, because in that situation, Pierre is acting as an individual, not as the agent. I kid you not. So, what are the chances of businesses actually doing this? Almost none. And the GDPR is, a teeth grinder for a variety of reasons, and this is just kind of an example. Now, we're not going to get into the GDPR here. It goes way beyond the scope of this video, and I'll be creating GDPR videos, and there'll be a playlist on them here in the future. But it is a major change in privacy law. So make sure you understand the requirements, particularly if you're selling there, or even if you're just offering free services or something there. You need to make sure you understand the territorial scope provision, which is found in Section 3. And then if you have to comply, all the rest of it. So what about in the U.S.? Are we going to see something similar to the GDPR? And no, at the federal level, probably not. If we do get a federal privacy law, a general one, it's probably going to be fairly toothless. And the reason for that is we have Googles and Facebooks of the world, lobbying like mad and cutting checks right and left to politicians. So we'll probably get a law and it'll probably sound nice, but it may be toothless, or, certainly not be what the GDPR is. However, California, where I'm located, of course, has gone off the map in this area, and they have passed the California Consumer Privacy Act. It was passed in the summer of 2018, and it's often referred to as GDPR light. So it's similar to the GDPR. However, it's not nearly as brutal. The penalties are not nearly as brutal, but it is going to be the de facto national privacy law in the United States, unless you want to block all your traffic from California and you don't want to sell into California or anything of that sort, which of course you can do, but that would probably do a lot of damage to your business model, because California has a huge population. So the California Consumer Privacy Act doesn't actually go into effect until January 1st, 2020. However, there's a 12-month look-back period, so you need to be able to control your content, control your personal information. If somebody asks how you've used it in the past 12 months, you need to be able to tell them. Again, we'll be doing a different set of videos on the California Consumer Privacy Act, but just know that it is out there floating around and is potentially something you're going to comply with, or going to need to comply with. The California Consumer Privacy Act is also very poorly written. There was actually, in California, you can put initiatives on the ballot for an election, and this occurred with the California Consumer Privacy Act. And there was a wealthy real estate investor up in San Francisco who thought the GDPR in Europe was the greatest thing in the world, and so he pumped out all the money necessary to go get signatures from voters in California to put it on the ballot. The problem with the initiative was the way it was written. It would have violated a number of other laws. There would have been complete chaos. There would have been no time period for companies, to adjust to the new requirements. It would have just been a huge mess. And so, in a bit of political trickery, based on the fact that the initiative had such high numbers from an approval perspective, it was just obvious it was going to be approved. The California legislature decided, well, how about this? Take it off the initiative, and instead we'll enact the law now. But then let us make changes to it so that it'll be, not so deadly from a legal perspective, and not cause so much chaos in California once, the law is enacted. And the real estate investor agreed. And so, whereas it took between 4 and 6 years for the GDPR to be drafted and approved, the California Consumer Privacy Act was approved in 7 days. and written and approved in 7 days. And so, as you can imagine, it has some language in there that's not great and a bit confusing. So, we can expect plenty of court challenges to it, but nonetheless, you're probably somebody who's going to want to just go ahead and comply with it. It's not going to be too bad, particularly if you're already compliant with the GDPR. So let's talk about privacy policies, assuming you're just in the United States and you're not worried about all of those things. There are some errors that we see in privacy policies, and there's one classic one that is just baffling to me. Okay, so let's be honest. A lot of people go out and they just buy templates for privacy policies, or maybe they copy them from other sites, or who knows what they're doing. If you do that, you're at risk of really screwing things up. So where do we see this? Where is this a problem? I like to call this the stupid privacy policy tricks. The number one problem that we see is that people will say, we will not sell, share, or rent your personal information. Now, it sounds like a noble thing. I mean, we're going to protect your personal information. However, if you put that statement on your privacy policy, and remember, the FTC is going to enforce that against you, as will courts, I have a simple question for you. How are you ever going to sell that business? Because think about it. What is the value of your online business? Well, in most cases, unless you're very unique, a big part of that value is going to be either your mailing list, which consists of emails of people, that's personal information, or your client list. And that, again, is obviously going to contain all kinds of personal information. Well, if you can't sell those two things because you promised your users that you wouldn't, you're kind of screwed. So let's look at an example. The most famous example in this, and you may have already heard about it, is True.com. It was a dating site. True.com was doing fine, but its parent company was having all kinds of financial problems, and it went into bankruptcy. And so when that happens, all the assets of the parent company are also dragged into bankruptcy, which included True.com. Now, another dating site came in and thought, aha, here's a quick way to build up our member list, and expand. And so they offered $700,000 for the member database of True.com. That company was called Plenty of Fish. And attorney generals in various states started objecting to the sale. And they said, look, the privacy policy, that was presented to all of our consumers in our state, all our citizens said that True.com would not sell, share, or rent their personal information. Well, they're trying to sell it right now. And the court agreed. Because that's exactly what True.com was trying to do. And they invalidated the sale. So the $700,000 sale went pfft. And eventually, later on, I think the domain was sold for, I want to say, something like $100,000. So there was a massive loss of value. And you're going to have that problem with your website if you're making those kinds of stupid promises. Again, think these things through, or have an attorney draft them. I mean, obviously, I'm an attorney, so I would advise that you have an attorney draft these things so you don't face plant. But even if not, you need to really think these processes through. Otherwise, you can really screw the pooch right from the outside of your business. So the final thing, Google Alerts. Why do I have Google Alerts on here? Well, privacy law is changing so quickly and so radically that if I was you and I owned a website or an app, I would do a Google Alert once a week for privacy and just see, what comes up. And you'll be able to catch big stories that go by so that, if something comes up that looks like you need to be concerned about it, you can address it with an attorney. The alternative, of course, would be just to retain an attorney that will, keep you informed. But we're a little expensive in that regard. I'm happy to do it for you, but doing a Google Earth that's going to keep you up to date on any major changes would probably be the best approach from a financial perspective. So that's it for today's subject. Is a privacy policy legally required? Practically speaking, yes, it is. And as we move forward through 2019 and on into additional years, I would expect that it's going to become a hard and fast requirement with the U.S. national privacy law at some point. So if you have any questions or comments, feel free to contact me. The best way to contact me is through SoCalInternetLawyer.com. Just use the contact page. Again, that's SoCal, like Southern California, InternetLawyer.com. Feel free to subscribe to this channel. We'll be issuing quite a few more videos on internet law topics and privacy as well as the GDPR and the California Consumer Privacy Act. So that's it for today. Have yourself a good one, and thanks for watching.